Our Heavenly Father, the fount of all goodness and grace, the cause of wisdom, the source of intelligence, we welcome you, O Lord, to this auspicious gathering of your beloved, who continuously give you thanks for every opportunity to learn something new and become fruitful to the works of your creation. We humbly come to you, not because we are worthy, but because we find ourselves in need of you, who is our strength and our hope, to continue despite the challenges we face in health, prosperity, and our solidarity with one another. We pray that today's gathering, made possible by the grace of advancements in technology and social media, becomes successful in its endeavors, so we can offer it back to you as our humble offering to honor you, glorify you, and love you through our deeper connection with everyone. May we find bliss in today's session and become more productive children and co-creators of the earth. This we ask and pray through Christ our Lord. Amen.
Good morning, everyone, and welcome to Caso Discurso 4th season of Bar Ops Pilipinas 2020-2021, the best bar ever webinar lecture series. I'm Meg Reyes, a graduate of the Ateneo de Manila University School of Law, and I will be your host for today. Of course, first thing in the morning, I would like to greet our esteemed law school deans from all over the Philippines who are tuning in with us today through Facebook Live. And of course, the staff of the Philippine Association of Law Schools and the PUP College of Law. To our online viewers, good morning as well. Thank you for tuning in this early, and I hope you had your breakfast already because we will be needing the energy to digest the lecture today. So, as we speak, this is already the fourth installment of Caso Discurso. And what is Caso Discurso? Caso Discurso is a lecture series every Monday for the month of September, which will discuss recently decided cases on the bar subjects and is brought to you by the Philippine Association of Law Schools, the PUP College of Law, in collaboration with Central Bookstore. Of course, we would also like to thank our event sponsors, Rex Bookstore and My Legal Wiz. If you want to know more about our sponsors, please watch these videos.
It is a noble aspiration to want to dedicate one's life in service of those who are oppressed and defenseless against the unfair and the unjust. It is an admirable advocacy in an adult, but it is awe-inspiring for a child to dream of speaking for those who are voiceless, to stand up in defense of the law and the common good. Because while every child dreams of a future, not every child is like you, who dreams of shifting society and changing the world. But life brings many possibilities. You may have chosen to push through the roadmap to your goal, or you may have changed your priorities, opted to explore, preferred to discover the world, or work on yourself first before moving towards your dream. Regardless, what's destined for you will always call you back. A dream deferred is not always a dream denied. Rex Education helps in building that dream every step of the way. For 7 decades, legal education has been at the heart of Rex Education, providing learners and practitioners with market-leading materials covering every discipline of law. Rex Education has become a standard in textbooks at every stage of a learner's journey, and it shows through the 70 years of being the most preferred by students, authors, professors, and thought leaders.
Estudyante pa lang ako, 1990, yung mga professor, ang piniprescribe nila, yung mga law books, ang publisher, Rex Publishing. So at that time na nagsulat ako ng book, so I decided to let Rex Publishing to publish my book. Bilang isang author ng law books, napaka-importante sa akin na yung mga librong sinulat ko accessible sa mga estudyante. Ang Rex Bookstore kasi napakaraming branches niyan eh. Hanggang Mindanao meron silang mga branches at napakarami nilang ahente na personal na pumupunta sa mga eskwelahan para may offer nung libro ko. Pati na rin yung mga libro ng mga ibang authors. So yun ang nakikita kong dahilan. Kaya ako, pati na yung mga ibang authors ng law books, nagtitiwala sa Rex Publishing.
Rex materials helped me in reviewing for the bar exam. Most of the books that I used in law school were published by Rex, and I practically used the same old law books during the bar review, as they were complete and comprehensive. Being then a working student, it was financially hard to buy new books. Good thing, Rex offered these law books at an affordable price. Also, the books published by Rex are known for their quality. The law books that I purchased from Rex and those that I borrowed from the school library, mostly published by Rex, became my strong armor, weapon, and constant companion as I hurdled the challenging life in law school. It is an honor to become part of Rex's family, and I am proud and happy to be with the best publisher in legal education.
Rex Education implements an uncompromised editorial process to ensure quality content. In fact, Rex Education law books have received numerous book centenary awards by the Supreme Court. Because legal education is continuously evolving, Rex Education continuously innovates in legal education. There have been challenges, but Filipinos have always risen above, and we are thankful for the support.
Rex Education's legacy in championing lifelong learning continues despite the changes in the landscape of legal education. And because we recognize those changes, Rex Education is able to provide the appropriate solutions. Rex Education digital products and online platforms made our learning materials more accessible to the learners, which enabled them to have a better grasp of their dreams of becoming a lawyer.
For you, who's taking the leap, Rex Education has prelex in preparation for law school admission exam. For you, who's uncertain but keeps on striving because your dream is not yours only, but of your family and the society. No matter the challenges, you move forward because every minute means 100 words read. Rex Education has reliable textbooks and codals that you can depend on in your study of law. To your dream and is excited to bring pride to your family. Rex Education has bar reviewers to gear you up for your review subjects and help you pass the bar. For you, who's braving new beginnings, Rex Education has instructive books and learning solutions for new and seasoned lawyers.
Cliche but still, knowledge is power. Knowledge of the law enables us to reason out in an adverse situation. My Legal Wiz is here to empower us.
Speaking on behalf of the law students from Negros Oriental.
Yan yung mga actual questions na sobrang open-ended, hindi masyadong detalyado.
Today, we are introduced to another innovation, the My Legal Wiz and Ask Free Legal Advice or Ask Leia. My Legal Wiz is an innovative online platform for legal knowledge, documentation, and research services that can help our micro, small, and medium enterprises without spending immediately on technical legal references or without getting a professional retainer for their legal issues and queries.
This is going to be very interesting, not only to lawyers but also to all who are in need or will be in need of lawyers. The interesting thing about it, however, is that you may not have to consult a lawyer in person anymore. You simply need to click your gadget and you are able to access legal content that you may need, whether you are a businessman, a legal researcher, or labor and tax professional.
This is regarding the books and resources. Kasi they don't have a Rex bookstore in their area.
Regular employee na siya. However, hindi yun ginrant ng kumpanya na. You are entitled to separation pay of at least 1 month pay for every year of service kapag regular employee ka. Yun yung hinahabol niya. So if you qualify as a regular employee earlier than in 2019, then your separation pay shall also be counted retroactively to cover the earlier years of service as a regular employee.
It's about time that they should be educated on how to address some of these legal concerns, and they can access this through the tip of their fingers with My Legal Wiz online platform. So I would like to thank My Legal Wiz for initiating this roadshow caravan for our businesses to be able to educated on these concerns.
Research at the tip of your fingers, ganyan po kadali ang My Legal Wiz. Kaya nga iniinganyo natin po ang ating mga kababayan, hindi lamang hindi lamang po yung mga eskwelahan sa mga law schools, Attorney M, kahit yung mga private companies, lalo na po mga LGU, mga
LGU sa Attorney G.
Di ba yung mga nasa gobyerno natin, mga ahensya ng pamahalaan, i-try nyo po ito dahil ito po yung malaking tulong sa kung paano po kami nakinabang dito. Ang Puntahang Legal ay nakikinabang dito, ang mga estudyante ng pamantasan ng Lungsod ng Maynila ay nakikinabang, kayo din po gusto namin makinabang.
Kaya naisipan namin na gumawa o siguro i-maximize natin yung paggamit ng technology So nakita nga namin itong My Legal Wiz. Dito na kami naghahanap. Nagda-download kami ng mga forms. So wala kami ibang ginagawa kundi pag-download. So fill up na lang namin yung form. Re-reviewin na lang namin.
Do sari-sari stores and online shops that have capitalization lower than 20,000 pesos need to print official receipts at the BIR?
We recommend that you still get a BIR certificate of registration and get an authority to print official receipts. Namatay from whom they did not inherit anything kasi wala kang property, pero nakatanggap naman sila sa lolo nila. So, ang kadagdagan na kaalaman lang po.
Again, thank you to our sponsors. Without them, this event would not be possible. We are truly grateful for doing this for the bar takers. To our online viewers, you may also show your support to the Philippine Association of Law Schools by sending some stars through this Facebook Live. Also, I would just like to remind everyone that you may ask your questions by posting comments at any time during the duration of the lecture. Now, during the past weeks, we already had a lecture in remedial law, commercial law, civil law, and taxation law. Today, we move on to another bar subject, which is labor law. Now, without further ado, help me in welcoming our speaker for today. She is the Executive Vice President and a member of the Board of Trustees of the Philippine Association of Law Schools. She is the managing partner of Abad and Associates Law Offices. The author of the book on Compendium on Labor Law 5th edition and a co-author of the labor portion of Volume 2 of the Pre-Week Reviewer for Jittery Bar Takers. She is the legal counsel for Philippine Association of Colleges and Universities. She is also a bar review lecturer on labor law topics and at the same time, a MCLE lecturer on labor law and education law. Everyone, please welcome the Dean of Adamson University College of Law, Dean Ada Abad.
Magandang morning to everyone. Honored to be here as part of the Caso Discurso 2021, so-called the best bar ever of our Justice Maverick Marvic Leonen. It's going to be a really different bar examinations. This is the first time that we will have digital and localized digital bar exams. And let's just hope that we will be able to do this notwithstanding the pandemic. So I had been tasked to do the updates in labor law. Thank you very much for our sponsors, PUP College of Law, Dean Jim Testin. Thank you for continuing with this Caso Discurso for the 4th year, no? And Rex Bookstore, to whom we have given our profound gratitude, especially for publishing the new Jittery Bar Reviewer of our group, and the Central Bookstore for publishing my dad's books, and Legal Wiz. No? Maraming salamat. So let us start with the updates in labor law. Okay, so what would the Justice Marvic Leonen bar be like? Because he has said that this will be the best bar ever for 2020 and 2021. Now, the bar examination, as he has said, no, in our several meetings with the Philippine Association of Law Schools, is simply a qualifying level. The examinee will be tested on basic competence and knowledge of key legal texts and canonical doctrines. The questions will therefore be textual and canonical. Only the text of the law plus the basic principles and canons which had been consistently upheld by the court. This is in relation to the interpretation of the law. Plus, he promised that areas of strong dissent will not be preferred. Okay? So the 2021 bar examination will not focus on the ratio decidendi of a particular case, which means that he will not focus on the rule of law on which the judicial decision is based. However, they will focus on canonical doctrine. And what did he mean by canonical doctrine? He said, well, a doctrine is a well-settled principle of law, or an interpretation of law, or a definition, or a procedure. But it is not enough that it just be a doctrine. He said it must be canonical. And sabi namin, what is canonical ba talaga to you? And he said, well, it must be a doctrine that must have been often repeated, reiterated unanimously over a period of time, over several generations of chief justices. So sabi niya ganyan, things that have been in place for 20, 30, 40, 50 years that have remained consistent, that is what the bar will focus on. So the law, and in terms of jurisprudence, what has been consistently upheld all throughout these years, that is what we will focus on. Okay? Now, I just remind you that the cutoff period for the 2021 bar examinations, according to the bar bulletin, for Supreme Court decisions, September 30, 2020, and with respect to laws, rules, issuances, until June 30, 2019. No? So let's start with employer-employee relationship, because that is actually the basis of the entire labor law. No? Remember the general rule number 1. The existence of an employer-employee relationship is a condition sine qua non for the application of labor laws. Then remember the principle of incorporation, which is in terms of the labor code being automatically incorporated into the employer-employee relationship. So much so that the minimum labor standards and benefits, as well as the political rights to self-organization, are deemed incorporated and inherent once you are hired by your employer. And that is so even absent an employment contract. So even if there is no employment contract, remember that the labor code and the social legislations will be deemed incorporated into that arrangement. Okay? Now, so how do you know if the person is your employee? Remember the fourfold test. And these are just doctrines that I give you before we tackle the cases. So remember the fourfold test, and I give you the mnemonic which was bequeathed to me by my father during my bar examinations of 1990. And so this test, the fourfold test, has been here since 1960. So try to remember what these are. So the mnemonic that I give you is Southwest Disaster Control, SWDC. S stands for selection and hiring. Whosoever selects and hires you in all probability is your employer. W stands for wages. Whosoever pays you the wages or compensation in all probability is your employer. D, disaster, stands for dismissal. No? Southwest Disaster Control. So disaster, dismissal. Para matandaan niyo sa bar. Whosoever dismisses you has the right to terminate you in all probability is your employer. But the Supreme Court said, and in a long line of cases. And so therefore, this is what we call canonical, okay, doctrine. The control test is the most important test of all. And it means that this is the employer-employee relationship is deemed to exist where the employer has the right to control not only the conduct of the employee in relation to his work. Now, this is the millennial definition. This right to control the conduct of the employee in relation to the work. But I urge you to memorize the classical definition, no? Which is used by Justice Leonen. And this is in the case of Parahele versus GMA Network, July 13, 2020. This is still well within your coverage. So this was a complaint for regularization, which was subsequently converted into an illegal dismissal case plus non-payment of salaries and wages, plus regularization, filed by 30 cameramen against GMA7. And their work services ranged from 2 years all the way up to 13 years for some of them. Now, GMA7, of course, denied the existence of an employer-employee relationship. They were saying, these people are not our employees. They are merely substitutes or relievers for those people who were absent for that particular day. And therefore, the services of these complainants were engaged only when there is a need for additional workforce or when there is an absence from the regular workforce. Now, the complainants definitely were saying, we are supposed to be employees. We are in fact regular employees because the work that we do as cameramen are necessary or at least desirable in the usual trade or business of GMA as a broadcasting agency, as a broadcasting company. Hindi ka naman makaka-operate as a broadcasting company without us, the cameramen. So they were saying that notwithstanding the fact that their employment could be intermittent, the fact is the work that they do is necessary, no? Necessary to the main business of GMA7. So the labor arbiter dismissed the complaint. It found that there was no employer-employee relationship. The NLRC and the Court of Appeals, on the other hand, said, yes, there is an employer-employee relationship, but these cameramen are not automatically regular employees by the mere fact that they do work which is necessary in the usual trade or business of GMA7. So nakita nyo ngayon, magkasanungat na, no? Yung kanilang decisions. So they went up to the Supreme Court, no? A petition for review on certiorari. So the question now is, how did the Supreme Court decide this case? No? How did you think the Supreme Court decided on this case? And the Supreme Court here said, ito through Justice Marvick yun, and that's why inuna ko na tong kasong to, because I wanted you to see how he thinks, no? And he's very liberal in favor of the employees. He said, number one, the cameramen are employees. Why? Because he checked the fourfold test and found out that all of these tests were actually being exercised by GMA7. Okay? Now, in terms of the control, no? Tingnan nyo yung naka-blue. Yan yung ginamit niyang definition of the control test. So I urge you to try to memorize that. And the control test, this one is lifted from the first OneSCRA case of LVN Musicians Guild. Kaya ito, sigurado ko, ito yung tinatawag niyang canonical doctrine. Kasi since 1961, this particular definition has remained in place since 1961. So this is canonical doctrine, people. Remember this. So what is the control test to him? An employer-employee relationship is deemed to exist where the employer for whom the services are rendered reserves the right to control not only the ends to be achieved, but also the manner and means by which the ends will be achieved. So ulitin nyo, the employer for whom the services are performed reserves the right to control not only the end to be achieved, but also how it will be achieved, the manner and means to achieve the end. So please take note of these key phrases, because in the bar examination, in as much as we are anticipating 12,000 examinees, the examiner, even if they were 3 of them now, for the first time, tatlo examiners per bar subject, the fact of the matter is that they will still have a lot of test books to check. And so they will try to look at the keywords and the key phrases. So the keywords are right to control not only the end, but also the manner and means to achieve the end. The how to control, okay? Now, as regards the control test, why is it that the Supreme Court said, oh, there is really control? Well, take a look at what GMA could do, no? The recordings and the shoots were never left to the discretion of the cameraman. It is GMA telling them where to shoot, when to do it, and then what are the schedules. And if they were supposed to record or tape some, do some tapings, they could not leave the work premises. Sometimes they would have to do overnighters. So in any event, it's now obvious that the GMA Broadcasting had control of the work to be done by the complainants. Okay? Now, question. Are they regular employees? Kasi dito, sinasabi ng GMA, okay, they might be our employees, but they are simply casual employees. Now, 2 things. For the very fact that they have worked intermittently or continuously for a period of at least 3 years, kasi ang terms ng engagement nila 3 years na eh, definitely you know they are not casual employees because they have gone beyond the 1-year period required by law. And so therefore, they are considered as regular employees. But take a look at the, if you were to read the case, GMA 7 was saying, you know what? At the very beginning, they are casual employees. Now, oops, merong background sound. Okay. So, sabing ganyan, at the time of their engagement, they are supposed to be regular already. They're not even casual employees because at the time that they were hired, they were doing jobs which were necessary or desirable to the usual trade or business. Now, the classification of employment is determined by law, regardless of the contract. So, if the work that is to be done by these people are necessary or desirable, it now appears, according to Justice Marvick Leonen, that they are regular. You can't even make them casual. If at all, only probationary. But you cannot make them casual because a casual employment is one where the work that they were hired to do is simply ancillary to the main business of the company. Okay? So here, the Supreme Court said here, an employee is deemed casual if he or she was engaged to perform functions which are not necessary or desirable in the usual trade or business of the employer. Okay? So, I hope that was clarified. That is the case of Parahele versus GMA 7. Okay? So petitioners, tingnan nyo medyo mabigat yung sinulat ni Justice Marvick dito. This is a little bit different from the usual because the previous Supreme Court cases would indicate you can put them as so casual if it is just short-term employment. But here, he goes one step beyond. He says, petitioners were never casual employees precisely because they performed functions that were necessary and desirable. They did not need to render a year's worth of service to be considered regular employees. Wow, ang bigat. This is a little bit new. Huh? This is a little bit new. Okay? So you will now see how Justice Marvick Leonen thinks. It's really for the employees. I'm getting a little bit of feedback and I can't even hear myself in my hello?
Yes, Dean, sorry po. We're trying to figure out where that noise is coming from. Pero
It must be coming from another phone of Angge.
Ako po. I'll tell her po, Dean.
Yeah.
Pero from the stream po, it is very clear po, Dean.
Okay, because I can't hear myself.
Okay po. So just
Okay.
try to fix it po.
So now, let's now go into, because you juxtapose employer-employee relationship with independent contracting. And why is that so? Because in this instance, the usual Supreme Court cases for a long period of time, if you will recall, a person who is being alleged as the employer can always say that this person who is claiming to be my employee is not my employee because he is employed by somebody else. Okay? So if there is a third party that they can point out to, they will say that party is an independent contractor. So that employee is the employee of the independent contractor and not mine. So I would want for you to memorize what are the elements of independent contracting versus job contracting arrangement or job contracting arrangements. These are two interchangeable terms. No? Huwag kayong malito kasi pareho lang yan. Job contracting, independent contracting, pareho lang yan. Now, some in the industry, they call it outsourcing. That is the same thing. No? Outsourcing is another name, but the legal name is actually independent contracting or job contracting. Now, how is it going to be valid? Okay, because you have labor-only contracting, which is prohibited under the law. So memorize what are the elements for a valid independent contracting arrangement. Okay, memorize nyo. So take a look at your Article 2, Article 106 to 109, and then your Department Order 174, series of 2007. Okay? The mnemonic that I give you is another one that was crafted by my father for my bar examinations in 1990. So that's almost 31 years already, no? So I Arm Free Capital Teamwork R&D. I invite you now to write it down. No? Write that down. Now, you can subdivide that into three components. Okay? Underline or encircle the words I Arm Free because that is one grouping. Okay? And then another grouping, which is one element, Capital Teamwork is another grouping. Encircle that. And then R&B is another component. So you have three components, I Arm Free, Capital Teamwork, R&B. So let us do it one by one. We're already trying to memorize now. Independent. The independent contractor, kaya nga independent kasi may independent business siya. So pinakamadaling tandaan yung letter I. Ano yon? Independent. He has his own independent business. A, he works for his own account. R, under his own responsibility. M, using his own means and methods. No? Free from the control of the principal except as to the results. Take a look at that definition. It flows from your control test, which I asked you to memorize earlier. The control test says that the employer is the one who controls not only the ends, but also the means. Dito, yung independent contractor is free from the control of the principal except as to the results. Kasi the principal can, kaya di ba, can control the results, but not the manner and the means by which to achieve the results. Okay, so I arm free, that's the first component. It talks about how, what are the components for being an independent contractor? Ano yung independent? Now, capital teamwork. The second component talks about capitalization. And capital, so the independent contractor is capital in the form of T, tools, E, equipment, M, machineries, work premises. Okay? Capital in the form of teamwork, tools, equipment, machineries, work premises. Memorize nyo na ngayon pa lang. And then, the last component is very important. You remember the solidary liability of the principal vis-a-vis the independent contractor. Now, Department Order 18A and 174 of President Duterte, the newest one, 2017, says that the contract between the principal and the independent contractor must already contain a provision where the principal recognizes the rights and benefits of the independent contractor's employees that are deployed to him. So sabing ganyan, the service agreement assures the independent contractor's employees of all the rights and benefits under the law. So much so that if the independent contractor fails to pay, di ba? If the independent contractor fails to pay the wages of his employees, then the principal is held solidarily liable thereto. So, itong letter C, pina-strengthen yan, no? Yung the requirement of solidarity liability has been strengthened by the incorporation of a provision in the contract between the principal and the contractor. Okay, so now, so take a look at the basic premises, no? Not all who work for you need to be your employees. The second premise, this is a contractual relationship between the principal and the independent contractor. The third premise, itong tandaan nyo, every time you read the Supreme Court case with a trilateral arrangement, tandaan nyo tong graph na to para nakikita nyo sa bar. So you have the principal, you have the independent contractor, and you have the employees of the independent contractor. In this particular diagram, we're using a security agency as the independent contractor. Okay? So klarong-klaro na yan, trilateral. Now, fourth premise, the vinculum or the connecting factor between the principal and the independent contractor is a job or service. It is not employment. It is simply a civil contract. Okay? No, so there must not be any control. But the result that the premises must be secured belongs to the principal. Okay? They can dictate. Now, fifth premise, the vinculum of the relationship between the independent contractor and his employees is an employer-employee relationship, in which case this is a labor contract. Okay? So you can now see that there are two contracts here, no? A civil contract and a labor contract. Now, last premise, the sixth premise, the principal must not have any control over the independent contractor, except as to the results. Okay? Of course, the independent contractor will have control of his employees. Claro? Okay. So now you already know there are two contracts involved in a job contracting arrangement. Between the principal and the independent contractor is a civil contract, and this is governed by civil code. So you have that case, no? Yung mga cases na yan, this is just a civil contract. Now, the independent contractor and his employees is a labor contract, and so therefore the labor code will apply there. However, the peculiarity is, if the independent contractor fails to pay his employees, then the principal is held by explicit provision of law, which is a peculiarity in Philippine law, no? the principal is held solidarily liable for the wages of the independent contractors' employees because of social justice and equity. Bakit? Because the services of the independent contractors' employees ultimately redounded to the benefit of the principal. Sino bang nakinabang, di ba? Ang nakinabang naman talaga yung principal. Kaya bayaran din niya. Kung hindi yan nabayaran, yung sweldo ng mga security guards. Okay, klaro? Now, so let's now go to labor-only contracting. And this is just an introduction to the next, the series of cases that we will talk about, the 2020 cases later. But I wanted you to have a background or basis. Nagme-memorize na rin kayo for the bar, okay? So ito ngayon. You already know the elements for independent contracting. Now I give you, what are the elements for labor-only contracting? I give you my father's memory aid. No cap plus direct or no control. So there are two ways. First way, you have to prove two components. The contractor does not have any capital in the form of tools, equipment, machinery, work premises. That's one. But aside from that, you must be able to show that the work being done by the contractor's employees are directly related to the main business of the principal. Okay, so no cap plus direct. The work that is being done by the employees of the contractor deployed to the principal are doing tasks or activities which are directly related to the main business. So what's a good example of directly related? No? Let's say we're a restaurant. I get a manpower agency, and the manpower agency gives me chefs, the cooks. Okay? So, if the manpower agency there does not have capital, and the employees that he supplied to me in the restaurant are doing jobs which are directly related to the main business of the restaurant, then that is labor-only contracting. Paano naging labor-only contracting? Kasi yung trabaho na ginagawa ng chef is intimately related to the main business of the restaurant. Hindi ka naman makakabenta ng pagkain kung wala magluluto, di ba? So, yun yung no cap direct. Now, let's juxtapose it with security agency. Educational institution, a school, meron kang security agency, tapos may security guards. Question, can you use no cap direct here para maging labor-only contracting yung security agency? Answer, no. Bakit? Kulang eh. Bakit? Kahit i-prove mo na no capital yung security agency, yung trabaho, the work that is being done by the security guards are not related to the main business of the school. And so therefore, they cannot be considered as regular employees under the first method of proving labor-only contracting. No? So, if the security guards want to be considered as regular employees of the school, what will they have to do? They will have to prove that the security agency does not have any control over the manner and method by which they do the work. So yun yung second way of proving labor-only contracting. The contractor does not have any control over the work of the contractor's employees. So now you will think, wow, if the contractor does not control the employees, the security guards, who controls pala the security guards? Then the law presumes it's the school because the security guards work within the school premises. And so therefore, if they're doing any work, it is presumed that it's the school that discharges and controls the manner and means by which they are to do the work. Kasi walang control na nga yung agency eh. So again, remember, two ways of proving labor-only contracting. No cap plus direct or no control. Klaro? Okay. So, makikita niyo yan sa Department Order 18, 18A, and Department Order 174. So, this is also doctrinal. Bakit? Kasi 2002 pa itong Department Order number 18, pinakauna. And this has been repeatedly cited in so many Supreme Court cases. So, no sufficient capital or investment plus, kaya end, plus the employees supplied by the company to the company, the principal, are performing work which are directly related to the main business of the principal. And then the second way, no contractor is no control. Klaro? Okay. So ito ngayon yung diagram para matandaan nyo for the bar. Ginagawa ko ng cartoons para masaya. Okay. So you have the principal, you have the so-called independent contractor, which is found to be labor-only contracting. That's why you put an X. And then you have the employees. What happens? The contractor, because he's a labor-only contractor, is deemed merely an agent of the principal. So mawawala siya sa equation. And the employees are deemed now directly hired by the principal as if they were directly hired by the principal as of the first day of deployment. Okay? So it is as if now the principal becomes the direct employer for all intents and purposes under the labor code. And so therefore he becomes liable for everything, not just the unpaid wages, not just the monetary claims arising from unpaid wages, but what? Everything. Even the political rights. SSS, PhilHealth, Pag-ibig, bakit? Siya na yung employer because he has control. Okay? Clear? Okay, good. So now, we have the case of Monsanto. This is a 2020 case. And Monsanto, as you know, is a domestic corporation engaged in agricultural business. The clientele are Filipino farmers that grow rice and corn, and then Monsanto promotes its products, no? Now, it entered into a service agreement with eStar. And eStar now, no, is an accredited job contractor with the Department of Labor. And then eStar employed this Martin Generoso and deployed them to Monsanto. So, ginawa niya, meron siyang hinire ng mga agricultural crop technicians, tapos dineploy, inassign sa Monsanto. So, your trilateral relationship will look like this. You have Monsanto, and then you have eStar here in the middle, and then you have the complainants. Okay? So, ganyan yung trilateral relationship. Now, nangyari, itong mga complainants, they were told that their functions were going to be made redundant. Okay? And so eStar formally terminated their employment, prompting these complainants to file a case for illegal dismissal against both the principal, Monsanto, the alleged independent contractor, eStar, and all of their corporate officers. Okay? Now, the labor arbiter said, yes, they are employees because eStar is a labor-only contractor. There is no control, and the fourfold test apparently did not apply there. Now, so the complainants were dismissed by Monsanto for an authorized cause. And what it was for the reorganization of personnel in order to streamline Monsanto's operations. However, due process was not observed. So they were saying, Monsanto, ikaw ang employer niyan. But although valid yung termination nila because there is really a reorganization, due process was not observed. Okay? NLRC rendered the decision affirming the labor arbiter. Okay? Now, what happened in the Court of Appeals? Ito na. The Court of Appeals, on the other hand, ruled that they are regular employees because they have been performing work that is usually necessary or desirable in the usual trade or business of Monsanto for more than 1 year. And it appears here that E-Star, okay, has the power. So sinasabi dito, reverse. Bakit? Ang tunay na employer niya, E-Star, hindi Monsanto. So, Court of Appeals went against, the decision of both the labor arbiter and the NLRC. So, Court of Appeals said this is a legitimate job contracting arrangement. Now, knowing that there are two contradictory findings between the labor sector, the NLRC and the Court of Appeals, they went up to the Supreme Court, no, on Rule 45. Sabing ganyan, well, sabi ng Supreme Court, yes, we can give due course to this petition for review on certiorari, precisely because you have contradictory findings of fact here. Okay, so the question is, who is the employer, Monsanto or E-Star? Supreme Court said Monsanto is the employer. Why? Because it had control over the conduct of the work of the employees of E-Star. Okay? So ang ginamit dito yung second way of proving labor-only contracting, yung no control. The contractor had no control over the conduct of the work of the employees it deployed to the principal. Okay? So kinuwento ko na kanina, di ba? So if it is not the agency that is controlling the conduct, who will control? So it is presumed that it is the principal. Okay? So that is the Supreme Court decision in the case of Monsanto. Sabing ganyan, no? Supreme Court may review the factual findings considering that contradictory findings of the NLRC and the CA. The control was established by the following: the hiring, the direct control, no? And sabing ganyan, if indeed E-Star is the real employer of the private complainant respondents, it should be exercising the power of control over them and not Monsanto. The evidence points to the conclusion that E-Star is not a legitimate legitimate job contractor, but rather a labor-only contractor. E-Star is not the employer of the private respondents. Okay? Okay, now let's go into another point. Burden of proof is always upon the employer to show validity of the exercise of its management prerogatives, especially as regards termination of employment. This is doctrinal canonical. Okay? This is canonical doctrine. And so therefore, try to remember it by heart. Because whatever it is, that has remained the law or the doctrine for as long as I can remember. Okay? As early as the 1940s, 1930s. Okay? So general rule, burden of proof is placed upon the employer. Exception. The complainant employee, however, has the burden of proving the fact of hiring and the fact of firing. No? So anong ibig sabihin nun? General rule, in terms of the entire employment, no? It's the employer that bears the burden of proving the validity of the exercise of its management prerogatives. However, the complainant employee bears the burden of proving first the fact that he was hired and last the fact that he was fired or he was dismissed. Okay? And those are Supreme Court cases, one of which is Remoticado versus typical construction of Justice Leonen. Okay? And Supreme Court said, there can be no case of illegal termination where there was no termination of the employer. While in illegal termination cases, the burden is upon the employer to show just cause for the termination of employment. That burden arises only if the complainant employee has shown by substantial evidence the fact of termination by the employer. That is the case of Justice Leonen's Remoticado case. Okay? 2018 pa yan. Now, so again, the burden of proof rests upon the party who asserts the affirmative of the issue. So kailangan niyang ipakita talaga that he was hired, and failing which, then, he is not an employee. Clear? Okay. Now, in cases of rehiring, when do you start counting the period of employment? In case that you rehire an employee, when do you start counting the period of employment? Okay, let us now try to define first what an employee is. And you find that in Article 219, paragraph F. Why am I trying to delve into this? Because these are, preliminaries before the case, para lang maintindihan din niyo yung kaso. This is also textual. Remember the text of the law. Remember the text of the law and the canonical doctrines. So, sabi ng batas, an employee includes any person in the employ of an employer. The term shall not be limited to the employees of a particular employer unless the code explicitly states. Medyo malabo yung explanation na yan, no? Ang sinabi nung nakapula dyan, the term shall not be limited to the employees of a particular employer. These refer to the employees of an independent contracting arrangement, because they can be considered as employees of the principal if this was a labor-only contracting arrangement. No? Okay, now the better definition could be found in your Department Order number 40. And it says there, the employee refers to any person working for an employer. It includes one whose work has ceased in connection with any current labor dispute. Okay? The legality of that dismissal is being contested in a forum of an appropriate jurisdiction. So we have the case of Quadra versus San Miguel Corporations by Justice Marvick Leonen. He said there, where there is no evidence to the contrary, an employee's period of service is presumed continuous, and its reckoning point shall be the day the employee first came under the employ of the employer. It is not upon regularization, it is upon hiring. No? However, sabing ganyan, in the interim or interregnum, the employer-employee relationship, in instances where it is validly severed, if the employee returns to that same employer for work, then this could be considered as rehiring, in which case the length of service here will be reckoned from the day that the employee was rehired. Anong ibig sabihin nitong validly severed? There was valid termination on account of either just or authorized cause or failure to qualify as a probationary employee, or that the person had retired, or that the person had resigned. In those instances, naputol, okay? The employment relationship ends. Now, if both parties choose to come back again, in short, the employee returns, return of the comeback, ano na ngayon? Then, you start from day zero. That employee that returns starts from day zero because there was a valid termination of the first employment relationship. Okay, that's the case of Quadra versus San Miguel Corporation. Now, yung nangyari dito sa kasong to kasi, 60 employees filed the case against Lipercon and San Miguel. Itong Lipercon, makikita nyo sa maraming kaso ng San Miguel, siya talaga ang manpower services ng San Miguel. No? In fact, ito nga yung mga Bustamante versus NLRC na kaso of 1990s to 2000, no? There, where the bottle washers and the segregators, they were actually asked, Lipercon, no? They were hired by Lipercon and then deployed to San Miguel. In any event, no? Medyo matagal tong kasong to kasi umakyat pa ng Supreme Court tapos bumaba for execution. In any event, ganito nangyari. So, yung may siyam na natira na lang dahil yung iba, sa tagal ng panahon, nagsettle na lang. So, there were 9 remaining employees, no, that continued with the case. At the end of that case, when they went up to the Supreme Court said, Lipercon is a labor-only contractor. You rehired. They have to be reinstated. Okay? They have to be reinstated. So, because ang tagal-tagal na ng kasong yan, and then they were being asked to be reinstated, ayaw na nila tuloy na patagalin, the parties decided to come up with a compromise agreement. Sinabi, sige na nga, let's just finish this. We won't even continue with the questioning of the execution, no? Although we have our own arguments. So, binayaran ng San Miguel yung 9 complainants. They executed a quitclaim. And then, they complied with the decision. I-reinstate na yung siyam. Okay? However, nung binigay doon sa siyam, yung ID nila na bago, nakita nung siyam, bakit yung date of employment namin as of today? 13 years na ako nagtatrabaho. Dapat yung date of employment na naka-reflect doon sa ID, dapat as of 1991. Bakit ngayon lang, 2021? Sayang naman yung 20 years ko. Sabi ng San Miguel, teka lang, binayaran na namin kayo eh. We already paid you. That's why you have a quitclaim. You had already been paid for all the back wages, and your quitclaim says all back wages and all claims. So understood na yan. Even including the years of service plus separation pay, kasama na yan dyan. Okay? So how do you suppose the Supreme Court decided on this case? Because contention ng mga tao, dapat all the way until the first day of our employment. Kasi kaso naman ito ng illegal termination eh. Sabi naman ng San Miguel, bakit? Nag-quit claim na kayo Nakalagay damot sa quit claim, you will already waive all other claims. And now we're saying that when you come back, you start from day 0 because you'd already been paid. What do you think? Supreme Court here said the reckoning date should be from the very first day of employment. Why? Because this was an illegal termination case. Remember what I told you earlier, the definition of employer from the beginning, di ba? Yung Department Order number 40, sinabi doon, an employer is one who works for an employee is one who works for another. It will include even one whose services had already been terminated, the validity of which was questioned in a proceeding. Okay? So in short, when you file a case for illegal termination, you are for all intents and purposes still considered an employee of the company. It is for that reason also that you are also given back wages, because all the time that the case was pending, you are supposed to have been working and earning wages from that company. So you are considered an employee for all intents and purposes. So this was, the argument of San Miguel here was really invalid or incorrect because, there was no indication there that they even included separation pay or retirement pay in the quit claim, So, in cases of rehiring, when do you start the counting of the period? The Supreme Court in this case said, distinguish between rehiring by reason of valid termination or resignation as against continuation of employment due to illegal termination. This is not really rehiring in the real sense of the word. Why? Because you have not been terminated. The termination was deemed illegal by the Supreme Court. And so you continue to be an employee for all intents and purposes under the law. So if it is an illegal termination and you are now reinstated back to work, definitely your years of employment should be all the way from the very beginning because there was no valid termination. Clear? Maganda itong kasong to, no? Okay, so that is the case of Quadra versus San Miguel. Quadra versus San Miguel. Okay, now, so sinabi lang ng Supreme Court dito, these are the doctrines, no? Karandang, Santa Catalina, Philippine Village Hotel, these are 1980 cases. Sinabing ganyan, an employee who returns to work for the same employer is considered a new hire if prior employment was validly terminated. The reckoning period begins on the day that the employee was rehired. However, if he returns to work upon an order of reinstatement, he is not considered a new hire. He is deemed to have remained under the employ of the employer. Okay? Claro? Okay. Now, I'll give you copies of these handouts. I'll give it to Pals. Okay. So, next item. So, ito na, no? I-remember yung employee definition. Term shall, ito. It includes one whose work has ceased in connection with any current labor dispute, the legality of which is being contested. Okay, binalik ko lang para lang matandaan lang ninyo. No? Okay, so let's now go into termination of employment. Now, in termination of employment, remember that you have two distinct and contradicting positions of the employer as against the employee. Okay? Now, in the middle stands the state. And the state has to balance the interest of these two. So, the employer says, I have the right to terminate, that is part of my management prerogatives. On the other hand, the employee says, but I have the right to remain in employment because I must be secure in my tenure. So how does the state balance these two conflicting interests? First, remember, na pag-aralan na natin to kanina, the burden of proof is always upon the employer to show the just cause, the just or authorized cause for the termination of the employee. Number two, there must be substantial evidence to prove the just or authorized cause of employment. So remember, substantial evidence, that is textual, no? Canonical, textual. Bakit? Remember yung definition ng substantial, na? This is at the lowest rung of the evidence, the requirement for evidence. Substantial evidence has been defined in a long line of cases. That amount of relevant evidence, relevant competent evidence, which a reasonable mind might accept as sufficient to justify a conclusion. Okay? Try to remember that. And if you can put that in your bar, so much the better. Okay? Now, so the penalty, so the first is burden of proof upon the employer, and there must be substantial evidence. Second, the penalty imposed must be commensurate to the offense committed. Why? Because in that case of Book Media Press, as reiterated in a long line of cases as well, 2019 case, ni-reiterate ulit, sinabi, a grave injustice is committed in the name of justice when penalty imposed is grossly disproportionate to the wrong committed. Okay? Now, third, remember, in order for it to be a valid termination, there must be just or authorized cause and due process of law. Okay? So, remember the grounds for termination. Tatlo yan, ha? Baka nakakalimutan nyo. There are three grounds. Just causes, Authorized causes. What's the third? Alam niyo yan. Good. Failure to qualify as a regular employee. Very good. Di ba? Pero that is peculiar only for probationary employees, di ba? You already know that. Very good. Hindi na kayo mahihirapan sa bar. Papasa na kayo. Okay? So, let us now go into authorized causes for termination. Memorize. Direct. This is the mnemonic given by my father again. D-I-R-E squared C. Okay? So now, D stands for disease. I for installation of labor-saving devices. R-E, retrenchment. R-E, redundancy. Closure. So, memorize it in this manner. D-I-R-E-R-E-C. Okay? Hindi ko na ipapakita yung iba kong mnemonic kasi medyo bastos. Alam yan ng klase ko. Pero tandaan nyo lang. Every other finger. Tandaan nyo. D, first R-E, retrenchment. Last C. Fold these two down. Kikita nyo? Disease, retrenchment, closure. Huh? Now, what is that? Separation pay is 1 month for every year of service or half month for every year of service, whichever of the two. Mali. Ulit. Again, erase. Nagkamali ako. 1 month pay or 1/2 month for every year of service, whichever of the two computation this is higher, is that which will be given to you. What do we mean by 1 month or 1/2 month? Kasi ang 1 month is the general rule. Kumbaga, kahit mga 10 araw ka pa lang, you will still get 1 month. That is the default. You will always get 1 month. But if you compute, no, half month for every year of service, naka 10 taon ka, that's practically 5 months pay. So, comparing it with 1 month pay as against 5 months pay, then that 5 month pay is the one that will be given to you. How do you compute that? Half month for every year of service. Okay? So again, half month for every year service. Ano yung natira? Ito. Separation pay for for installation of labor-saving devices and redundancy. 1 month pay or 1 month for every year of service, whichever of the two computations is higher, is that which will be given the employee. Okay? Memorize nyo na lang yan. Madali na tandaan eh. Yung every other. Basta tandaan nyo, D-I-R-E-R-E-C. Okay? Memorize nyo yan for the bar. Claro? Now, serious misconduct. Let's now go to serious misconduct. Serious misconduct has been defined as an improper or wrong conduct. It is a transgression of a definite rule of action, a forbidden act, which is willful in character and implies wrongful intent. It is not merely an error in judgment. This definition, canonical. Okay? Canonical, kasi ang tagal na ng definition na yan. Lahat ng serious misconduct, palagi nililift yung definition na yan. So, memorize nyo na. Now, the important thing here is this. For misconduct or improper behavior to be just cause for dismissal, the same must be related to the performance of the employee's duties. And it must be shown that the employee has become unfit to continue working for the employer. Sa ginawa niyang ito, napakahirap tanggapin na siya bilang trabahador sa kumpanya. Okay, so we have the case of Stalfilo versus Tequilo. Ano nangyari dito? No? Here, the Supreme Court ruled on a case of physical violence being inflicted by one employee against another. Question is this serious misconduct? Will it be serious misconduct if the physical violence was not in any way related to the performance of one's work? Second question, will all cases of physical violence be considered as a ground for termination? Now, the Supreme Court here said violence does not necessarily mean automatic termination. You have to look at the totality of the circumstances under which it was created. Okay? So, even if it was committed well within the company premises, during company hours, it does not necessarily translate to an automatic termination. Take a look at the circumstances. Are there mitigating circumstances there? Or if the circumstances call for some kind of self-defense, then you also have to apply that. Okay? But even then, if you are going to terminate any person, then the employer bears the burden of proving that in terms of serious misconduct, this was work-related and has rendered the errant employee unfit to continue working. Okay? So, ano nangyari dito sa kasong to? Aba merong kaibigan fellowship, no, na require. The employees were all required by the company to attend. Now, this Tequilo, the complainant did not attend. In fact, what he did was, kumbaga, nag-escape siya, and then, no, nakipag-inuman na lang doon sa likod, no? Kasi banana plantation so doon siya sa malayo, nakipag-inuman sa ibang mga tao. Now, habang nakikipag-inuman siya, while he was drinking, yung isa niyang kasamahan, na kasama niya sa trabaho, dumaan, no? And this was his parang assistant. Bagong-bagong empleyado to. He chanced upon Tequilo and was eventually prevailed kasi nga bagito, sumama ka na dito, ka na, huwag ka nang pumunta doon sa kaibigan ng fellowship. Dito ka na, inom ka na, tagay! Inom naman sila. Ganyan. So ngayon, nung nagkakagandahan na ng inuman, itong si Tequilo was already expressing some kind of resentment against the company because he wanted to get higher pay and some kind of a performance incentive. But, it fell on deaf ears. So he felt so bad. So he told this Tequilo, yung bagito, pare, kung ako sa'yo, huwag ka na lang dito magtrabaho. Maghanap ka na ng iba. Dito naman, yung mga tao dito, hindi naman binibigyan ng importansya. Okay? So, yun yung sinabi niya dun sa bagito. Yung bagito sinabi, alam nyo, kung may problema po kayo, bakit hindi nyo na lang i-raise sa management? Napikon ang Tequilo kasi lasing na siya. Sabi, taragis na bagito to, boom! Binanatan niya. Okay? Bugong, bugong, bugong. Pagbanat niya ganyan, siyempre nasaktan yung tao, yun na. Please explain in writing why you should not be held responsible, why you should not be terminated in accordance with our company code of conduct, blah, 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 blah. So they went, this guy eventually filed a case. As, questioning the legality of the termination. The labor arbiter said, yes, this is a valid termination. The drinking and the fighting happened inside the company premises. It was duly proved. And this act constituted serious misconduct and willful disobedience. The NLRC reversed the labor arbiter's decision. The NLRC said, he cannot have been illegally dismissed because you were not able to connect that act of drinking with the performance of his job. He was not performing official work at the time that he mauled the bagito. And the Court of Appeals agreed with the NLRC. So you now have two contradictory decisions. They went all the way up to the Supreme Court. How did the Supreme Court decide? You think? What do you think? Here, the Supreme Court said that this was actually a valid termination. So tandaan nyo uli, yung requirement, it is the transgression of some established rule or action. It implies wrongful intent and not merely error in judgment. Now, ang importante dito sa kasong to, remember the requisites or the elements for valid termination on the ground of serious misconduct. Number 1, the misconduct must be serious. Number 2, it must relate to the performance of the employee's duties. Number 3, it must have been performed with wrongful intent. Now here, the Supreme Court went on an extended discussion. Sinabi lang niya, look, not every fight within the company premises would automatically warrant dismissal. Hindi naman porke nangyari yan. But, sabi niya ganyan, here, it appears that this act was actually done in performance of his work. Why? Because he should have been at work at that time. Okay? Dito tingnan nyo. The work-relatedness and the wrongful intent cannot be questioned. Tequilo himself admitted that he mauled Gayon out of emotional disturbance. The attack was clearly unfounded because Gayon had said or done nothing to sufficiently provoke the attack. While it might be true that Tequilo acted out of resentment, the same resentment was essentially attributable to his own work-related neglect. It follows then that the attack was connected to the substandard performance of Tequilo's duties, and it was fundamentally rooted in his confounded notions of workplace dynamic. Taken together, these show that Tequilo's violent act amounted to serious misconduct. Why? Because the incident disturbed the peace in the farm, breached the discipline expected by the company of all its employees, and as such, this Tequilo, being ill-mannered, is ill-suited to continue working, as shown by his perverse attitude and by the possibility that the attack may be repeated. Okay, and so the Supreme Court set aside the decisions of the NLRC in the Court of Appeals, reinstated the decision of the labor arbiter. Okay? Okay, now here in redundancy, again, remember, the default is 1 month pay or 1 month pay for every year of service, whichever of the two computations is higher is that which will be given you. Now, what does redundancy mean? If you are going to be terminated by way of redundancy, the company is actually telling you that your services are already superfluous. It is a duplication of an existing job. There are just too many of you doing the same thing. And so therefore, your job is actually in excess of what is reasonably required for the efficient operations of the service. Now, inasmuch as it is not your fault, but an exercise of management prerogatives by virtue of social justice and equity, the law now says, then you must be paid some kind of separation pay because you have not done anything wrong anyway. Okay, but this is simply an exercise of management prerogatives. And so this particular definition of redundancy is coming from the Wiltshire file case, 1991 pa yan. So apparently this is also what we call as doctrinal, okay? Canonical doctrine. Kaya sinabi ito in the seminal case of Wiltshire file. Okay? Now, so this is a Leonen case, si Acosta versus Matiere. Here, Justice Leonen said, okay, if you are doing redundancy, although this is an exercise of management prerogatives, you must be able to show, however, by way of substantial evidence, that you have made use of some kind of reasonable and fair criteria in determining what positions will be declared redundant. Okay? So as you already know, in management prerogatives, no, Although management prerogatives are presumed to be valid from the very beginning, it has to comply with 3 requisites. No, you remember the requisites? It must be done in good faith, for the furtherance of the valid interests of management, and not purposely to circumvent the rights of the employees. So in that instance, although management would have the exercise of management prerogatives, it must be able to show that there was no circumvention of rights and this was done in good faith. And how do you show that? Well, you present what are the criteria for determining why this position was made redundant. That is part of the burden of proof required of the employer. Okay? So that is the case of J. Acosta. Ano naman nangyari dito? Ito lang kasi hinire siya, no? Dito si Mattiere, hinire si Acosta as a technical assistant. Initially consultant, naging empleyado. Okay? And then eventually, after a while, he was deemed terminated on account of redundancy. Now, he did not believe the redundancy. Bakit? Because once he got terminated, merong kapalit doing the same job as his. Now, if it was really redundancy, then you would presume that you will not need to hire anyone anymore. Di ba? Merong nag-reply sa kanya. Sabi niya, ba't niya ako tinawag redundant? Bakit kayo kumuha ng iba? Di ba? So, kinwestiyon niya yung validity ng redundancy program. Okay? Now, the labor arbiter decided there was illegal termination. The labor arbiter said there was no substantial evidence showing fair and reasonable criteria. On the other hand, the NLRC reversed the labor arbiter and said, yes, this was a valid exercise of management prerogatives. There was apparently done in good faith for the furtherance of the valid interests of management and not purposely to circumvent the rights of Acosta. But there is no indication that he was paid the separation pay. And so therefore, in accordance with law, you pay him 1 month pay for every year of service. Okay? So may makukuha pa rin yung tao. Hindi pumayag yung tao. Sabi niya, hindi. Invalid yung redundancy. So therefore, I must be reinstated. Mas malaki kasi yung back wages eh. Di ba? So sabi niya, I want to be reinstated. The Court of Appeals affirmed the labor arbiter decision. So with the contradictory decisions of the proceedings below, how do you suppose the Supreme Court decided in this case? Was this a valid exercise of management prerogatives, this redundancy program, or not? And the Supreme Court here said, no, this is not a valid exercise of management prerogatives. There was no valid redundancy program because the company failed to show reasonable criteria. Okay? So ganyan, no? Assuming that the respondents can declare some positions redundant due to the alleged decrease in the volume of the business, they still had to comply with the above cited requisites. This, they failed to do so. Hindi pinakita yung 3 criteria for determining who will be considered redundant. Okay? Now, sabi yan, the respondent's only basis for declaring the position redundant was that his function became unnecessary with the completion of the shipments. Okay? But why is it that somebody else was hired? Diba? Okay? So remember again, no? Yung redundancy. Now, how is it different from retrenchment? Retrenchment, as we said, there's a default of 1 month or the separation pay, which is lower, of half month for every year of service. Whichever the 2 computations is higher is that which will be given to you. Okay? But in retrenchment, remember that you must be able to show business losses. That is the main difference between redundancy and retrenchment. Because in redundancy, you don't need to show business losses. You only have to show fair and reasonable criteria to determine that this job of yours has become superfluous or a duplication of existing jobs, which is no longer necessary for the efficient operations of your business. Okay? So, take a look at the requirements for retrenchment and try to remember that by heart. So, the losses expected should be substantial and not merely de minimis. Meaning to say, yung ordinary day-to-day na losses. Hindi. Ang pinag-uusapan dito, substantial losses. Now, the substantial losses which are apprehended must be reasonably imminent. Okay? If it is not actual and merely apprehended, meaning na-anticipate pa lang ninyo, you can see that this is reasonably imminent. What do you mean by that exactly? You have not really incurred it. Hindi naman kailangan talaga na may losses ka na eh. But you can foresee in 3, 4, 5 months that you will lose these revenues. Bakit? Kasi yung kliyente mo, tinanggal yung retainer sa'yo. Or nag-end na yung contract. Example, supplier ka ng San Miguel or ng SM department store. And SM department store is approximately 70% of your entire operations. Okay? Pag nawala yung SM na kontrata sa iyo, definitely 70% ng income mo mawawala. So you can already foresee, mag-e-end yung contract sa December pero ngayon pa lang it's already September. Do you have to wait? No, the Supreme Court said if you can already anticipate and this is imminent and it is, you can already see that this is substantial, you can already start the retrenchment program as early as now. Okay? So, tingnan nyo to. The alleged losses, if already incurred, and the expected imminent losses which sought to be forestalled must be proved by sufficient and convincing evidence. Okay, these are requirements for retrenchment. This is not really changed. So this could be considered as textual, canonical. So we have another Justice Marvick Leonen case. This is the Team Pacific versus Parente. So dito, you have to show that there was fair and reasonable criteria again for this particular ground for termination. Okay? So, it's practically the same as here. Dito kasi illegal termination din eh. Ito, sinabi maternity leave, tapos hindi na siya pinabalik after she gave birth, no? And then, sabi, you don't have to come back, here you go. You are going to be terminated on account of retrenchment. But you have to show your losses. And if there are no evidence of losses, then you cannot make use of retrenchment. Okay? So it's already 10 o'clock. Let's take a break. I just have to drink water.
Yes, Padil.
Okay, Meg? Okay lang?
Yes,
Any questions muna before we break? Baka maraming nagtanong.
So far po din wala. They're just very thankful for the lecture and the lecture was very clear.
I can't see anything in my... So I'm doing Zoom and you're doing StreamYard.
Yes.
Okay. So thank you. Let's take a break for about 15 to 20 minutes and then we'll come back.
Okay pa din.
Okay, sige.
So to our audience, we will be back after a short break. Thank you.
It is a noble aspiration to want to dedicate one's life in service of those who are oppressed and defenseless against the unfair and the unjust. It is an admirable advocacy in an adult, but it is awe-inspiring for a child to dream of speaking for those who are voiceless, to stand up in defense of the law and the common good. Because while every child dreams of a future, not every child is like you, who dreams of shifting society and changing the world. But life brings many possibilities. You may have chosen to push through the roadmap to your goal, or you may have changed your priorities, opted to explore, preferred to discover the world, or work on yourself first, before moving towards your dream. Regardless, what's destined for you will always call you back. A dream deferred is not always a dream denied. Rex Education helps in building that dream every step of the way. For 7 decades, legal education has been at the heart of Rex Education, providing learners and practitioners with market-leading materials covering every discipline of law. Rex Education has become a standard in textbooks at every stage of a learner's journey, and it shows through the 70 years of being the most preferred by students, authors, professors, and thought leaders.
Estudyante pa lang ako, 1990, yung mga professor, ang piniprescribe nila, yung mga law books, ang publisher, Rex Publishing. So at that time na nagsulat ako ng book, so I decided to let Rex Publishing to publish my book. Bilang isang author ng law books, napaka-importante sa akin na yung mga librong sinulat ko accessible sa mga estudyante. Ang Rex Bookstore kasi napakaraming branches niyan eh. Hanggang Mindanao meron silang mga branches at napakarami nilang ahente na personal na pumupunta sa mga eskwelahan para may offer nung libro ko. Pati na rin yung mga libro ng mga ibang authors. So yun ang nakikita kong dahilan. Kaya ako, pati na yung mga ibang authors ng law books, nagtitiwala sa Rex Publishing.
Rex materials helped me in reviewing for the bar exam. Most of the books that I used in law school were published by Rex, and I practically used the same old law books during the bar review, as they were complete and comprehensive. Being then a working student, it was financially hard to buy new books. Good thing, Rex offered these law books at an affordable price. Also, the books published by Rex are known for their quality. The law books that I purchased from Rex and those that I borrowed from the school library, mostly published by Rex, became my strong armor, weapon, and constant companion as I hurdled the challenging life in law school. It is an honor to become part of Rex's family, and I am proud and happy to be with the best publisher in legal education.
Quality.
Rex Education implements an uncompromised editorial process to ensure quality content. In fact, Rex Education law books have received numerous book centenary awards by the Supreme Court. Because legal education is continuously evolving, Rex Education continuously innovates in legal education. There have been challenges, but Filipinos have always risen above, and we are thankful for the support.
Rex Education's legacy in championing lifelong learning continues despite the changes in the landscape of legal education. And because we recognize those changes, Rex Education is able to provide the appropriate solutions. Rex Education digital products and online platforms made our learning materials more accessible to the learners, which enable them to have a better grasp of their dreams of becoming a lawyer.
For you, who's taking the leap, Rex Education has Prelex in preparation for law school admission exam. For you, who's uncertain, but keeps on striving because your dream is not yours only, but of your family and the society. No matter the challenges, you move forward, because every minute means 100 words read. Rex Education has reliable textbooks and codals that you can depend on in your study of law. Rex Education has bar reviewers to gear you up for your review subjects and help you pass the bar. For you, who's braving new beginnings, Rex Education has instructive books and learning solutions for new and seasoned lawyers. And for you who's in the forefront of shaping today's finest lawyers, no more second guessing. Publish your book and depend on Rex Education for editorial, project management, promotion, and distribution. Whether it be education, practice, or profession, let Rex Education help you be the best that you can be. Everything that we
Cliché but still, knowledge is power. Knowledge of the law enables us to reason out in an adverse situation. My Legal Whiz is here to empower us.
Speaking on behalf of the law students from Negros Oriental.
Yan yung mga actual questions na sobrang open-ended, hindi masyadong detalyado.
Today, we are introduced to another innovation, the My Legal Whiz and Ask Free Legal Advice, or Ask Leia. My Legal Whiz is an innovative online platform for legal knowledge, documentation, and research services that can help our micro, small, and medium enterprises without spending immediately on technical legal references or without getting a professional retainer for their legal issues and queries.
This is going to be very interesting, not only to lawyers but also to all who are in need or will be in need of lawyers. The interesting thing about it, however, is that you may not have to consult a lawyer in person anymore. You simply need to click your gadget and you are able to access legal content that you may need, whether you are a businessman, a legal researcher, or labor and tax professional.
This is regarding the books and resources. Kasi they don't have a Rex bookstore in their area.
Regular employee na siya. However, hindi yun ginrant ng kumpanya na. You are entitled to separation pay of at least 1 month pay for every year of service kapag regular employee ka. Yun yung hinahabol niya. So if you qualify as a regular employee earlier than in 2019, then your separation pay shall also be counted retroactively to cover the earlier years of service as a regular employee.
It's about time that they should be educated on how to address some of these legal concerns, and they can access this through the tip of their fingers with My Legal Whiz online platform. So I would like to thank My Legal Whiz for initiating this roadshow caravan for our businesses to be able to educated on these concerns.
Research at the tip of your fingers, ganyan po kadali ang My Legal Whiz. Kaya nga iniinganyo natin po ang ating mga kababayan, hindi lamang po yung mga eskwelahan sa mga law schools, Attorney M. Kahit yung mga private companies, lalo na po, mga LGU.
LGU sa Attorney G.
Di ba yung mga nasa gobyerno natin, mga ahensya ng pamahalaan, itry nyo po ito. Dahil ito po yung malaking tulong sa kung paano po kami nakinabang dito. Ang puntahang legal ay nakikinabang dito. Ang mga estudyante ng pamantasan ng Lungsod ng Maynila ay nakikinabang. Kayo din po, gusto namin makinabang.
Kaya naisipan namin na gumawa o siguro i-maximize natin yung paggamit ng technology. So nakita nga namin itong My Legal Wiz. Dito na kami naghahanap. Nagda-download kami ng mga forms. So wala kami ibang ginagawa kundi pag-download. So fill up na lang namin yung form. Re-reviewin na lang namin.
Do sari-sari stores and online shops that have capitalization lower than 20,000 pesos need to print official receipts at the BIR?
We recommend that you still get a BIR certificate of registration and get an authority to print official receipts. Namatay from whom they did not inherit anything kasi wala kang property pero nakatanggap naman sila sa lolo nila. So ang kadagdagan na kaalaman lang po.
Galing-galing mo.
Tayo.
I am in awe. Would you believe nga, kailan lang ako natutong mag-digital online na banking? Is there a way by which first?
I'm just waiting po na mag-view tayo.
Okay. Siguro we end at 11 quarter because I have to go pa to the office. Huh?
Yan, so we're back na po. Thank you everyone for waiting. We are moving on to the second part of the lecture, but before that, we will address some questions from the audience first. We'll just wait for it to appear on the screen. To our audience, to our online viewers, you may post your questions in the comment section and Dean Ada will answer them. First question po from Mr. Robert Branya. During pandemic, there are a lot of company closing down, especially SME. Is retrenchment will first thing remedy by employer? Thank you.
Okay. Okay, Robert. This is a usual question these days, no? Even the Department of Labor recognizes that there are some companies, even the big ones, no, that will have to undertake retrenchment. But please take note that is supposed to be a last resort. The termination of employees during pandemic is actually discouraged. But it will not prohibit employers from doing so if there is really just cause for it, meaning to say there is really justifiable reasons for it. Now, when I say it's the last resort, a remedy of last resort, it means that you have to undertake other measures first, like cost cutting. You also have labor advisory, I think number 6, no, and 11, which says, as of 2020, April and May, that you also can undertake several flexible working arrangements, which means that you allow people no longer to go to on-site or on-premises work, but if they can just stay at home, no, and if you can probably do work, compressed work week. Now, if you have to cut down on their salaries, it means therefore that you are now cutting down as well on the schedules. Let's say, for example, you used to be a 6-day work week and they cut it down to 3 days or 4 days. That is also allowed for as long as the employees are duly notified, because the understanding here is that this is no work, no pay, no? So you will see that there are a lot of people now that are just doing, let's say, half pay kasi kalahati na lang ng sweldo nila. But under the circumstances, a lot of the people, a lot of the employees have agreed to take a cut in pay rather than be retrenched, because it would be more difficult to look for a job these days, because everybody else is retrenching due to the pandemic. But as I said, the Department of Labor discourages retrenchment. Please try to do the flexible working arrangements first. And if that plus your cost-cutting measures do not work, then at least you have some kind of substantial evidence to present the Department of Labor for your justification to undertake a retrenchment program. Okay? Mahirap talaga ngayon. Hindi madali ang nangyayari. And I don't think naman the companies also want to lose people, because when you terminate a person, remember that you are also depriving the entire family of his earnings. So it will spell probably, less food on the table, or that one of his children will not be able to go to school. It's a big responsibility if you terminate kasi. And I don't think any employer would really want to do that. If it were possible to keep everybody in the payroll, so be it. But sometimes you just have to bite the bullet if, on the other hand, the revenues are really down, that you have no other choice to ensure the survival of the company and to be able to keep afloat the rest of the workforce. So yon, talagang minsan at last resort talaga, pagka you're able to justify it, that will be allowed naman. Okay? What's the other question? I hope I was able to answer you, Robert.
Yan. Opo. We have more questions coming po.
Sige, go ahead.
This one po from Cooking Jubilo. Is the dollar order of extension of 6 months layoff due to pandemic valid, considering that under the labor code, it should not exceed 6 months?
Yes. I'm not sure of the number, but it is a Department of Labor advisory, no? The usual thing is that you are allowed to float a person on, put a person on floating status for a period of 6 months, but there must be a declaration of temporary cessation of operations, no? And this pandemic is something that had never been thought about before. We never thought this would happen. So everything was happening for the first time. So the problem was when the government declared in March 17 that total lockdown of ECQ noong 2020, and it lasted all the way until May. A lot of companies already had very difficult times keeping the operations afloat. And so they had to call for some kind of temporary closure. And then the 6 months was coming up, And suddenly we were struck again by another ECQ. Remember, noong August last 2020, it was the Philippine Medical Association and all the rest of the doctor associations that said, time out muna, we can't handle it anymore. There was a surge. There was a surge. And so the government again imposed an ECQ from August 4, I think, or 6 until 20. So it was a 2-week period again. And so the companies then were trying to get out of the rat hole, and suddenly, ito na, paahon pa lang, pinukpok na naman sila dahil meron na naman panibagong ECQ. So the government, remember when the government imposed the 2 months lockdown from March until May, no? Marami na nag-temporary closure noon, especially mga restaurants, yung mga sinihan, no? Restaurants, sinihan, gyms, ganyan. Marami na nagsarado. Yung iba, sinabi temporary lang because we still want to continue. The 6-month period ought to be from March, April, May, June, July, August, September. You see? Dapat mag-e-end na nung September, and yet we were hit by another ECQ. That's why the Department of Labor, under the circumstances, thought it best to, again, extend the 6-month period. But remember, the extension should have been for a period with due notice to the employees. With due notice to the employees, and really explain to them exactly what was happening. Now, at the end of that period, if the company is unable to give work to allow these people to return, no, then they will be required to pay separation pay. If they are losing, meaning to say they are experiencing substantial business losses, then they can already go into retrenchment program. Kasi ang redundancy, as we said, hindi dapat walang losses yan eh. So pag may losses, you usually say this is redundancy. Now, on the other hand, if this were total bankruptcy, like what happened in the North Davao case, then the Supreme Court had already said, and this is canonical doctrinal, sabi ng Supreme Court, if it is bankruptcy, tantamount to bankruptcy, then the employer cannot be compelled to even pay the separation pay, because you cannot squeeze blood out of stone, nor water from the desert. That is the exact wordings of Supreme Court Chief Justice Artemio Panganiban in that particular case of North Davao Mining. And that has been reiterated several times. But please take note, bankruptcy must have been filed as a proceeding by the company, no, in order for you to be able to really say that you are bankrupted, and therefore avoid the payment anymore of any separation pay. Okay, that's I hope it answers your question. Who asked the question, Meg?
George, sorry, nawala na po sa screen.
Okay, so I hope I made it, I was able to clarify.
Yes po. We have 4 more questions.
Go ahead, sige.
Okay po. This one from Mr. Kent Lanya. Main question, can the employer dismiss an employee on the cause that employee failed to report in the office due to the pandemic kasi takot magka-COVID despite various demands from the employers? Salamat po.
Again, wait. Kent Lanya. Can the employer dismiss an employee and the ground the employee? Okay. Mahirap pa tong kasong to kasi wala pang Supreme Court decision to Everything's happening right now. But let me tell you this. The Department of Labor has discouraged termination as much as possible on account of COVID. So much so that you cannot terminate a person for refusing to be vaccinated. Okay? Of course, I had a different proposition that if it were the employer that sourced out um, the vaccine, sila bumili privately, no? Sinorse out na. Dahil pwede na ngayon bumili commercially, sabi ng government in time, no? If the company requires the employee to get a vaccine before you can enter the premises, in order as well to protect not just yourself but the rest of the workforce, that would have been an exercise of management prerogatives. But, as I said, the problem is that there is no mandatory vaccination policy of the government. Now, juxtaposing that with the employee going to work. Now, the Department of Labor Advisory as well as the IATF protocols say that a person who has comorbidities or is pregnant should not be allowed to go to, not naman should not be allowed to work, but may stay at home. So the company will have to come up with some kind of alternative work arrangements. As I said, yung flexible working arrangements. However, there are certain jobs which cannot be done at home. Alam niyo yun, like driver. Di ba? Paano ka mag-work from home sa driver? Alam nga naman mag-drive ka sa loob ng bahay mo. Di ba? So, yun yung, those are certain kinds of, like messengers. He has to really go out. No? So, if at all, they cannot go to work, and they have already, in fact nga, ang nangyari pa nung pandemic, sabi ng Department of Labor, ituloy nyo yung pagbayad. Sabi ng iba, wala naman kami ibabayad. Sabi niya, i-charge ninyo, you charge it to your existing leave credits. Now, everybody, as we know, has minimum 5 days for every year of service. This is what you call the service incentive leave. So you charge the 5 days service incentive leave to that. Yung first pandemic natin, yung lockdown. Di ba tumagal nga ng 2 months? So, yung ibang companies kasi 15 days, na kaya yung 1 month. Paano yung pagdating sa second month, nung May hanggang June, no? Nung April hanggang May, kulang na yung leave credits. Sabi ng Department of Labor, well then, they will just have to go on no work, no pay. And so therefore, under the circumstances, if this person does not want to go to work because he is not vaccinated or that he has a lot of morbidities, that it is also dangerous for him to go out, then he just refuses to go to work, and the exhortation is, don't terminate him, but he will have to go on no work, no pay. Which means that for as long as he does not go to work, then he does not get paid. Because on the other hand, you cannot compel the management to keep on paying these people when they are not going to work anyway. Kasi nga, the principle is no work, no pay. So, in answer to your question, can you terminate? It will be frowned upon by the Supreme Court and the Department of Labor at this point, no? You don't want to do that, but he will have to go on no work, no pay. Now, if, on the other hand, there is no justifiable reason why they cannot go to work. Example, hatid sundo yan. Or yung trabaho naman niya is just at the desk job. He's not required to go out of the office. He's just in the office. And you have a bubble in the office. Then probably you can warn the person, no? Give him a warning. Pero it's a very tricky question. It's very dangerous. It's very difficult for me to decide on it. Kasi iba-iba ang kaso eh. You'll have to look at it from the totality of the circumstances that are existing. And also, you have to be, under the circumstances, humane. Okay?
Yes, Dean. Thank you, Dean. At this point po, we have more and more questions.
Okay.
Non-stop. Do you want to
Sige,
address
sige.
them now po, Dean?
Yes, mahaba pa sana yung lecture ko pero mas maganda na rin nagtatanong sila. Yes.
Okay
Sige.
po. Okay, so let's just wait for it to show on the screen. Okay, another question po from Miss Gian Palad. Question po, Dean Ada. Is the separation of employees in the workplace po based on vaccinated and not covered by the Equal Protection Clause or discriminatory po?
Okay. No Supreme Court decision yet, but you can already see from my answer earlier, no, that number one, there is no mandatory vaccination policy of the government. They could have if they wanted to. Remember, every child now has to have their measles, chickenpox, smallpox, all of those within the first how many months of the baby being born. They have to have mandatory vaccinations, no? That would be a policy of the government. However, at this point, number one, all the vaccines are only emergency use authorization. You're not even really sure what is the after effect. Diba? Number two, there is no mandatory vaccination policy also because you are not sure of the supply. Because when you have a mandatory vaccination policy, it means that the government can supply everyone with the vaccine and even give it out for free at the beginning. Now, as you already know, under the circumstances, we have had problems on securing the vaccines. And even then, they were saying that there is no more money. But then you hear about the Pharmally, etc., etc. So I don't even want to go into that, no? But yeah, that's the problem. You don't have any mandatory vaccination policy. So how can you separate somebody for refusing to be vaccinated or failing to be vaccinated? No? So as I said, kung yung management yung kukuha ng ano, dapat pwede. Pero yun na nga walang mandatory vaccination policy pa eh. So will the management put its foot down and say, as an exercise of management prerogatives, I demand? That can be a good test case. Yeah.
Okay. Thank you very much, Dean. Now we have a long question from Mr. John Kaiko Balmeo. Dean, Philippine Airlines recently filed for bankruptcy before the U.S. court. Hypothetically, can PAL invoke such bankruptcy case in retrenching employees, or is it necessary that a bankruptcy be filed in the country only?
I think under the circumstances, you may have to replead the petition here in the Philippines because you are not, under our jurisdiction, we are not required to recognize foreign judgments until it has been pleaded here. So you still have to, I think, file for bankruptcy here.
All right, we have another question po. This one from Mr. Christopher Lawrence Arnuco. Good morning, Dean. A case before the labor arbiter for illegal dismissal. If the labor arbiter orders the reinstatement of the employee who was illegally dismissed and the employer filed an appeal before the NLRC, what is the status of the employee? However, the NLRC reversed the decision of the LA and the employee assailed the decision before the CA. What is the status of the employee? And another question, I think. And the CA affirmed LA decision and the employer filed a petition for review under certiorari before
the Supreme Court.
Before the Supreme Court. I think he will also ask for the status of the employee.
Okay. Just look at our definition of the employee. An employee continues to be considered as such for as long as he or she has filed a case questioning the validity of the termination. And that presumption that they are employees shall continue until the finality of the decision. So if it goes all the way up to the Supreme Court, then they are considered employees. Now, if there are breaks in between, you must still get a finality of the decision before you may be able to determine whether or not they are entitled to the back wages. Now, for as long as there is a ruling that there is a back wages, no, then they're entitled to be paid that, especially in terms of the first stage of the reinstatement aspect of the labor arbiter's decision. That is already mandatory, so they have to get that. What happens if, as you say here, it was deemed to be a valid termination in the NLRC? Then, if it is a valid termination and they did not appeal, and it becomes final executory, then back wages will stop only until the NLRC decision becomes final. So, hindi siya nag-appeal, mapuputol na yan, mag-end yan. Ngayon, paano kung nag-appeal pa siya? Depending on the decision of the Court of Appeals, then it will run again, no? Assuming that the Court of Appeals says this is an illegal termination, dudugtong na ngayon. The entire time that the reinstatement, the NLRC said this was a valid termination, will be rendered moot and academic because the CA decision supplants that of the NLRC and says, "Uy, continuing pa rin yung back wages." No? Assuming na hindi siya na-reinstate all the way up to the Supreme Court, ganun din. So you better figure it out lang muna. Now, ang tanong, baliktad. Paano kung halimbawa it's the labor arbiter that said it was valid termination, and then the NLRC decided that it is an invalid termination? Question: will the back wages only run from the time of the NLRC decision, or will it run to the start? Answer: to the start. Diba? Kasi illegal termination daw eh. Now question: what if in the meantime, dito sa topsy-turvy decisions na yan, lumabas pala that it was a valid termination all the way up to the Supreme Court, and the Supreme Court said it's valid termination, and in the meantime, you put them on reinstatement by the payroll. So she had already been receiving the money by payroll. Question: can the company now demand that the person return all the monies paid by way of reinstated payroll reinstatement? Uy, valid pala yung termination. Lahat ng nakuha mong pera, ibalik mo ha? Pwede ba yon? Hindi, sabi ng Supreme Court. Kasi as far as they're concerned, once they have been reinstated, they have the right to earn a living until it has been reversed. So you are not required, you cannot be required if you're the employee to return it. Okay? That's the case of Garcia, I think, versus Pal.
Yes, thank you, Dean. Now we move to another question. This one from Mr. Christian Charcos. Is the quarantine period for those tested with positive or even exposed with COVID-19 still subject to no work, no pay policy?
Under the circumstances, the employer first must charge it to the leave credits. If there are no more leave credits, no work, no pay. But the employer can help you by filing the necessary SSS claims. Tutulong na lang by way of SSS PhilHealth. Then you process the application because it's considered an extended sickness, no? So yung benefits mo doon you can get. Anything that is beyond 4 days of sickness kasi you can claim.
All right, thank you, Dean.
That's all.
Yeah, at
So
this point, we may continue with the lecture and we can still address questions later if time permits.
Okay, okay, medyo iibayin ko na lang yung slides ko, sandali lang ha.
Okay.
Pause share ko muna. Tama ba yon? Pause share ko muna o stop share? Stop share ko muna. Okay, sige, dali. Hanapin ko lang yung slides kasi medyo ano na to. Punta na lang tayo sa OFW kasi maganda yung mga kaso doon sa OFW.
Alright.
Maraming Justice Leone na cases doon.
Okay pa.
Okay, teka. Ito muna, transfer. Tapos yung ano. What time is it?
It's currently 10:45 in the morning po.
Oh, okay. So we'll probably finish at 11:30. Okay lang sa inyo?
Yes po, Dean.
Am I sharing my slides now?
Not yet, Papa.
Okay, let's go muna to transfer of employees by way of management prerogatives. Do you see it?
Yes,
You see
Dean.
my slides na? Okay, thanks, Meg. Okay, so in transfer of employees, remember that this is an exercise of management prerogatives. Memorize again the 3 elements for a valid exercise of a management prerogatives. Number 1, it is done in good faith. Number 2, it is for the furtherance of the valid interest of management. And number 3, it is not purposely done to circumvent the rights of the employees. Okay? So it is part of management prerogatives to transfer you as an employee to any department where you can be most useful to the company depending on your academic qualifications and special skills, no? Now, one important case which is not very new, but this is no? This is a jurisprudential guidelines in the transfer of employees, ICT marketing. And this is actually a reiteration of doctrines of long standing which they pulled in together into one decision. Okay? Kaya sinabi nila jurisprudential guidelines. So ito na ngayon yung parang canonical doctrinal. Number 1, transfer is a movement from one position to another of equivalent rank without a break in the service and a lateral movement from one position to another of equivalent rank. Number 2, employer has the inherent right to transfer an employee for legitimate business purposes. Number 3, the transfer becomes unlawful where it is motivated by bad faith or discrimination or is a form of demotion. No? And lastly, the burden of proof is still placed upon the employer to show the validity of the exercise of that transfer and that it is not prejudicial, inconvenient, or unreasonable on the part of the employee. Okay? So, remember, when you say lateral transfer, no demotion in rank, no diminution in pay or benefits. And lastly, it must not unduly inconvenience the employee. The question now is this. What do you mean by unduly inconvenience the employee? Can the employee just say, nahihirapan ako, ayoko, I will not transfer? No? Now, take a look at this case of Chateau Royal Country Club, which was not asked in the bar. I was waiting for it last 2019. No? And here, 3 account managers from the Manila outlet. This is a country club based in Tagaytay, but they have an outlet in Manila, no? Para madali kasi para madali puntahan ng mga kliyente galing sa Manila. 3 of the managers there resigned, leaving the workforce in the Manila outlet without any supervisors. So, the owners thought, and decided, I will send 3 of my managers who are here in the head office in Tagaytay down to Manila. And these 3 officers refused, no? And they said, no, we will not do it. It's very inconvenient. Question. Can they allege that and refuse to transfer? In short, is this a valid transfer or not? What do you think? Sabi ng tao, inconvenient. Answer, here the Supreme Court said this is a valid transfer. This is a valid exercise of management prerogatives, especially so that there was no evidence that the company was acting in bad faith or had ill motivations in ordering their transfer. In truth, there was urgency and necessity of the transfer considering the resignations, the unexpected resignations of the 3 managers down there in the Manila outlet. Okay, so under the circumstances here, the Supreme Court ruled for the company. Okay, now you have one case of Kanyogan Credit. Ito din transfer, no? Pero dito, sinabi ng mga empleyado, kaya kami tinransfer kasi we were deemed to be very close to the former manager na tinanggal because there was a change in management. So they were saying, you know, this is an act of discrimination against us. When we were transferred, we complied anyway. But when we got transferred, for almost 3 months, they did not ask for us to do anything. We were relegated to, you know, menial jobs. So question, was this a valid transfer? No? And the Supreme Court, the company naman was saying, well, you were transferred in accordance with our reorganizational plan. Kayo, hindi kayo pumasok because you did not like the reorganizational plan. And so we have not terminated you. We have not terminated you at all. On the other hand, the employees were saying, well, the thing is this is already constructive dismissal because the atmosphere was so very bad we couldn't really work. Okay? So who do you think the Supreme Court, what do you think the Supreme Court decided that? Who was correct? The company or the employees? Ano tingin nyo? And the Supreme Court here said that this was an illegal termination. Okay? Dito kasi was the transfer of the respondents with bad faith. Were the respondents deemed to have abandoned the employment when they refused to report back? Were the respondents constructively dismissed? And are they entitled to back wages? Tuhog-tuhog yan. So, number 1, apparently dito, from an assessment of the facts of the case, the Supreme Court found out that this was actually constructive dismissal because at that point, management is supposed to prove the validity of the exercise of its prerogatives. And management miserably failed to do so. Why? Because if it was true that this was a valid and in good faith reshuffling of the people, why is it that they were not asked to do anything when they were transferred? No? So the Supreme Court here said, this belied the petitioner's claim that the respondents' services were greatly needed. And the Supreme Court gave credence to the idea that their transfer was only a ruse to cover up the management's distrust of these people. Kasi nga, they were closely related with the previous manager that they had taken out. So the petitioner's acts here clearly exhibited discrimination, insensibility, and disdain towards undesirable employees. So, because the respondents could no longer take what they felt was an act of oppression, then they considered themselves as having been constructively dismissed because this was akin to a demotion. So, they did not report to work anymore. Okay? So, Supreme Court said the respondents did not voluntarily abandon their jobs, no? And hence, yan yung ano. So, let's say, lumiit yung font. Okay. Migrant workers. What are the general principles of compensability of death or injury? So, first rule, we go for lex loci contractus or lex loci celebrationis. And it simply means the law of the place where the contract is made shall govern. Now, you have a lot of Supreme Court decisions on that. No? So you have Justice Leonen case of Samir overseas. This is an old case, 2014, but it's been repeatedly reiterated. So, akin to doctrinal canonical na siya. So, employees are not stripped of their security of tenure rights when they move to work in a different jurisdiction. With respect to the rights of overseas Filipino workers, we follow the principle of the law of the place, which governs this jurisdiction. Okay? Now, so, he talks also about the doctrine of processual presumption or the presumed identity approach. Ito yung sinabi ko kanina, no? The party invoking the application of foreign law or even a foreign judgment has the burden of proof of proving the foreign law. If the foreign law is not pleaded, or even if pleaded is not proved, then the presumption is that the foreign law is the same as Philippine law. Okay? So remember that. Okay. So now, number 2, rule of the principle of incorporation. We already discussed this earlier. For as long as there is an employer-employee relationship, then the labor code and all social legislation are deemed automatically incorporated in that relationship, even absent a written employment contract. No? So you have these cases, it's old cases, but this is doctrinal, no? Hindi na natin kailangan masyadong pag-usapan pa, pero it only says that the contract of labor is so impressed with the public interest that the new civil code explicitly subjects it to special laws on labor, collective bargaining, strikes, working conditions, hours of work, and similar subjects. Now, third, you have security of tenure. So the right to work and not to be terminated except for just or authorized cause and with due process still applies even with respect to overseas Filipino workers. Okay? So even if they had been deployed abroad, because the labor code is deemed automatically incorporated in that relationship, applying the lex loci contractus or celebrationis principle, then by necessity, the overseas Filipino workers cannot be terminated except for just or authorized cause and only upon compliance with the due process requirements. Okay? Rule number 3. Monetary claims of overseas Filipino workers are governed by the Republic Act 8042 as amended by 122 and not the labor code. No? Okay. Bakit? Because contractual sila. So that idea of back wages will not fly because it cannot be full back wages. They are all contractual employees. Therefore, relief such as reinstatement with full back wages or even separation pay are not applicable to OFWs because of the contractual nature of their engagement. Number 2, monetary claims for under Section 10 of Republic Act 8042 as amended will be available only for illegal termination. No? But we note the peculiarity. What is the peculiarity then? What is the peculiarity? Ito, tandaan ninyo kasi ito, Justice Leonen case din siya. No? Tingnan niyo itong nakasulat sa batas, sa 8042. Meron kasi dati na nakalagay na yung paragraph 2, his salaries for the unexpired portion of the employment contract or for 3 months of every year of the 3 months for every year of the unexpired term, whichever is less. That thing that I struck out has already been declared unconstitutional. So, what was left in Republic Act 9042 is this lang. Number 1 and number 2. Yeah? So, you consider yung or for 3 months that's already considered as deleted by the Supreme Court. So you have that case of Serrano versus Galant Maritime. This is doctrinal canonical. Okay? Section 10 of Republic Act 8042 was declared unconstitutional because it is discriminatory and in violation of the Equal Protection Law. And in this particular brilliantly decided case of Justice Alice Austria Martinez, she said, that matrix that she prepared, juxtaposing a person, a Filipino, an OFW with just less 1 year employment contract as against another OFW with a 3-year employment contract, if you were to juxtapose it together and compare, you will see na mas malaki ang makukuha nung 1-year contract as against the 3-year contract. No? Because those with less than 1 year are entitled to the entire salary of the unexpired portion. Whereas if it were a longer contract, only 3 months for every year of the unexpired portion, usually nga, tigbo 1 year, 2 years lang yan eh. Okay? So here, the Supreme Court struck it down. No? Now, as of now, how much can the illegally dismissed OFW claim by way of salaries for the unexpired portion of the contract? Meron pa bang 3 months, 3 months for every year now? Wala na nga. So ano na? Simple lang. Entitled to all salaries for the entire unexpired portion of the employment contract regardless of the duration of the employment. That's the answer now. Okay? Now, question. Paano to? Ni-reenact pala, that particular portion which we struck out earlier was reenacted in Republic Act 122 in 2010. Does that mean that the Congress had every intention and now shows the Supreme Court that this is what we really want? That if it is a longer contract, they're entitled to only 3 months for every of the expired portion of every year of that contract. Pwede ba yun? And here, Justice Leonen said, the reenactment of the same provision in Republic Act 122 cannot cure the unconstitutionality of Section 10 of Republic Act 8042. Okay, and this is the same case of Samir versus Joy Cabiles. It is an unbanked decision, and that's why we really have to remember that case. I have a strong feeling this will be asked. No? Okay? Now, what is the requirement for a successful claim for compensation due to disease, death, or disability? Now, why are we going into migrant workers? Because in the recent years, you will see that there are a bulk of migrant workers' claims that were passed by the Supreme Court. Ang dami na talaga ngayon. No? And so, therefore, I have a feeling that there will be questions in the bar regarding this. So, you have Justice Leonen case, Castillon versus Magsaysay Mitsui Marine. Now, the Supreme Court here, through Justice Leonen, said, in resolving the claims under the POEA standard employment contract, the element of work-relatedness only demands a reasonable link between the illness and the seafarer's work. It is not required that you have to prove that the work was the sole factor in the aggravation or in the incurring of the disease. The test is only reasonable proof and not direct causation. So take a look at that line, the one that I underscored. Yan yung importante dito. The test is only reasonable proof of work connection and not direct causation. No? And then we have another Justice Leonin case, Ebuenga versus Southfield Agencies 2018. And he wrote down, and this is actually textual, no? Textual na to. What are the requirements for the disease, for the compensability of the disease? And this is found in your section 32A of your POEA, no? It says there, for an occupational disease and resulting disability or death to be compensable, all of the following conditions must be satisfied. Number one, the seafarer's work must involve the risks described herein. Number two, the disease was contracted as a result of the seafarer's exposure to the described risks. Number three, the disease was contracted within a period of exposure. And number four, no notorious negligence on the part of the seafarer. Okay? Now, question. Ito maganda tong kasong to. I've always said that Justice Marvick is a maverick. Why? Because he tests the boundaries. He's really maverick, no? He's marvelous Marvick. Maverick. Bakit? Tignan niyo na lang to. May post-traumatic stress disorder arising from sexual harassment be used as a ground to claim disability benefits? Galing, no? So, this is the case of Justice Leonin in Tolyonco versus Court of Appeals, July 2020. So you have this guy, an OFW, who was sexually harassed while he was on board Mineral Water. And the name of the ship was Mineral Water. And he opted for voluntary repatriation. But unfortunately, contrary to the requirements of compensation, no, the procedure for availing of the compensation, he did not go to the company physician within 3 days from arrival at the point of hire. Hindi siya nagpatingin sa doktor, sa company physician within 3 days. Wala siyang proof. Pero a week after his repatriation, he filed a complaint before the OWA. And then after several months, then he filed for constructive dismissal against the ship owner and the agency, not the recruitment agency. He was now claiming that he should be compensated for not being able to go to work anymore because he suffered from post-traumatic stress disorder arising from that unfortunate sexual harassment case. Okay? So itong lalaking to, nakursunadahan ng isang foreign na puti na lalaki din at hinaharas-haras siya. So ang ginawa niya, in fact nga, medyo, if you want to read this case, it was a little bit graphic, no? And I never thought that I would be able to read those words. But yeah, this guy wanted him to, wanted the OFW to do certain things that were not very, not appropriate here. But, this guy, this Filipino got scared. So he told his friend, uy, samahan mo ko every time tatawagan ako. So pag tinatawag siya, may nangyari, no? Nung isang beses na tinawag uli siya, may nangyari. Sinumbong na niya dun sa friend niya. And then he just got so stressed out that the next day that it happened, he filed a case already. But not before he was threatened physically by this other guy, that white guy who na kinursunada siya. Na if you do something, I will get back at you, etc., etc. So, the question here is that, can he claim compensation on account of post-traumatic stress disorder because of this incident? Now, here, the Supreme Court said Okay, number 1, take note, no? Dito kasi, number 1, you already know the procedure. It is mandatory that after you arrived at the point of hire, you have 3 days within which to go to a company doctor to be able to, for the company doctor to be able to assess whether or not there is, you can be compensated for any illness or disability that you might have incurred while on board ship. He was not able to do so. So in this particular case, the Supreme Court said, unfortunately, you have no evidence whatsoever that you went to a doctor. And you have also, although you have evidence that says here, on account of this post-traumatic stress disorder, you have your private doctor saying that, you have been sexually molested and has already affected your mental health. This is not sufficient as evidence for the claim of compensation, no? So tingnan niyo yung sinabi dito. This was the private doctor. Sinabing ganyan, the diagnosis is that he could not return to his job as a seafarer because there was now persistent avoidance, persistent anger, problem with concentration, sleep disturbance, recurrent intrusive and distressing memories of the traumatic incident. Unfortunately, there was no diagnosis of the same by the doctor because they were not, given the opportunity to do so. So the labor arbiter, the NLRC in the Court of Appeals found that there was constructive dismissal. Why? Because of what happened, he was forced to decide just to go home instead. However, the Court of Appeals, the NLRC, and the labor arbiter said, he cannot claim disability. No? So, inakyat niya, ang tanong ngayon, nitong lalaki, bakit hindi? Could he still claim? That's why he went up to the Supreme Court. Wala ba talaga ako makukuha for whatever has happened to me? Kasi wala talaga siya makuha eh. Nagpa-repatriate siya, binalik naman siya. Wala naman siya makuha ng disability. Sabi ng Supreme Court through Justice Marvick. The question is that, number 1, is the 3-day rule on post-employment mandatory? Number 2, is the post-traumatic stress disorder work-related or work-aggravated? And number 3, whether or not he's entitled to damages. And here, you will see now how maverick Justice Marvick is. He says, petition is partially granted. Bakit? Sabi niyang ganyan, number 1, it is correct. He cannot claim compensation on account of disability because he failed to comply with the procedure. He failed to comply with the 3-day reportorial requirement. But all of the 3 agencies below, the labor arbiter, the NLRC, in the Court of Appeals recognized that there was indeed sexual harassment. And so therefore, there must be some kind of damages here. Okay? So here, sabi dito, take a look, no? If he is, the reason why they could not give the disability, sabi ganyan, you failed to comply with the 3-day note, the 3-day period. If you are indeed suffering from a debilitating mental capacity, how come he had the wisdom to file a complaint with the OWA a week after he signed off? He said in his position paper, when I was repatriated, the company physicians examined me. But there was no evidence whatsoever of that physical examination. Wala talaga. So, ang binigay lang niya yung private doctors niya. So they couldn't give that particular, compensation on account of disability. Pero sabi niyang ganyan, This person was harassed twice in one night. Although he managed to escape in both instances, there was no way for him to avoid CO, Chief Officer Oleksiy. The only way he can protect himself from further sexual advances or unwanted sexual contact was to request for repatriation. By no means can the petitioner's repatriation be considered as voluntary because he had been pushed against the wall with no other recourse. Therefore, this is constructive dismissal and hence he is entitled to his salary for the unexpired portion. Hallelujah. Diba? Ang galing nung twist. Ganda. No? And, eto pa, hindi pa siya tapos. Sabi ni Justice Marvick, lest this court be misunderstood. We recognize that it takes time for victims of sexual harassment to come forward. Perhaps more so because the victim is male. And there is a fear that he will be stigmatized by a sense of loss of masculinity, etc., or the fear of being perceived as homosexual. It is established that the petitioner suffered some sort of injury, but the pieces of evidence he submitted are not sufficient to convince this court that he had been permanently and totally disabled, and hence the court is precluded from awarding the disability benefits. But it is not because of his non-compliance with the 3-day repertorial rule, which he intimates could be, in this instance, moved back. He can be flexible and liberal. Sabi niya kaya, because of his non-compliance. It is not because of the non-compliance. But, sabi niya, because there is barely any evidence to support the claim for disability benefits. Diba? And hindi pa siya tapos. Last na. Ito na yung last parting words niya. And this is something like you will see how he thinks. To restate, sexual harassment can happen to anyone and everyone. Our society has often depicted women as being the weaker sex and the only victims of sexual harassment. It is high time that this notion is corrected. To consider women as the weaker sex is discriminatory. To think that only women can be victims of sexual harassment is discriminatory against men who have suffered the same plight. Men who have been victimized by sexual predators. Ta-da! Ganda. Hanep. Cutting edge. Well, I've never read any case like this. Meron pa ba? No? So, this is new. July 8, 2020. Okay? So, anong nangyari? So, by way of, payment, monetary claims, moral damages. So, meron na siya, no? Number 1, he can get the unexpired portion. So, he can get the unexpired portion of the contract because this was considered as constructive dismissal. Then he gets moral damages. But please take note, the amount was increased to 100,000. No? Because this court cannot turn a blind eye to sexual harassment that he had to endure while on board MV Mineral Water. And then, he said, we also reinstate and increase the award of exemplary damages. Why? Because this should serve as a warning to all shipping companies and mining agencies that it is their obligation to ensure safe working conditions for our seafarers. Galing. And then, because he was forced to litigate, then attorney's fees will also be awarded. So very, very, wow. Really for the employee. Talagang binigay niya lahat sa empleyado. But all within the bounds and the parameters of the law. Hindi talaga pwedeng ipasok sa
hindi pwede talaga ipasok sa sa yung sa compensability kasi number 1, wala na siyang 3-day rule, tapos number 2, wala pang ebidensya talaga. So dito nyo na lang idinaan. Constructive dismissal. Fantastic. Okay? Okay, question. Do the provisions of the labor code still apply to OFWs who have been deployed abroad and are retrenched by the foreign principal? Answer, yes, of course. Doctrinal, canonical. Because, as we say, wherever you may be deployed for as long as you are a Filipino, the laws of the labor code and the social legislation will attach to that employment contract wherever you may go. Okay? Especially if this was entered into here in the Philippines. So Philippine law recognizes retrenchment as a valid cause, but the foreign principal who retrenches the OFW abroad must comply with all of the requirements for retrenchment, which will include the 1-month notice to both the employee and the Department of Labor and the separation pay. Plus, as we learned earlier, all of the criteria, that the losses must be duly proven and that there is reasonable and fair criteria to determine retrenchment. Okay? Question, what is the employment status of seafarers? Textual, canonical. Seafarers are contractual employees. Okay? And this is reiterated by Justice Leonen in Mansala versus Marlo. Okay? And then, you now have, naubos na yung aking mga slides kasi hindi pa naaayos. Siguro yung isa pang magandang kaso na pag-aralan ninyo, yung kaso ng Adamson University. Papakiplug lang yung aking university din. Justice Leonen came out with that Adamson University case. And in that particular case, it was a question of termination by the university of the union president who had uttered remarks, PTI, or something like that, anak ng puta, something like that, against a student. And even assuming the Supreme Court there through Justice Marvick said, so the question was whether or not this was valid termination on account of serious misconduct because it was not done in the performance of work, etc., etc. Now, the Supreme Court here from Justice Marvick Leonen said that, number 1, although it might be argued that the words anak ng puter putang ina could be considered as a just a phrase that is said, nonchalantly without any real meaning to it. The problem with this person was that his demeanor after was the one that really affected the decision, because his demeanor was that of antagonism, and he was not even apologetic. Even when the university tried to fix it without having to go to court, by having the student and the parents meet with the union president, it was unavailing because he was so very antagonistic, and he even refused to say sorry. Sana kung nag-sorry, sabi nga ng Supreme Court case to, hey, if he had just been, if he had just apologized and his demeanor had changed, then probably another decision, this decision would not have come this way, But as you can already see, the Supreme Court also said that this was a form of misconduct, serious misconduct, because as a person in authority and as a teacher, he had to comport with this with certain parameters, for deportment as an academic personnel. Okay, And so therefore, the Supreme Court in this case said that this was a valid exercise of management prerogatives. This person was validly terminated for serious misconduct. Okay? Okay. And then you have other cases of Claret versus NLRC, which is in relation as well to classification of employment, and juxtaposing the case of Brent School, no? Because in that particular case, the woman employee of Claret was just placed on a term-to-term contract. And they said that this person knew that she was just a temporary employee, but she had been working for a long time. So sinabi ng Supreme Court, you have to be able to show if you are using Brent School. Remember that in cases of fixed-term contracts, Brent School is actually the exception, because the presumption is that if it is really a meeting of the minds, then you must be able to show that the other party, not the company, but the employee, had entered into this arrangement of a fixed-term employment, waiving his or her rights to security of tenure, knowingly, voluntarily, and with full knowledge of the ramifications of such term employment. Okay? And so therefore, the understanding is that when they entered into that fixed term employment, they were dealing with each other on a more or less equal footing. But under the circumstances, in this case of Claret, it does not appear that the woman had been informed of the ramifications, and neither did she really fully understand what having a term contract meant. And in fact, the Supreme Court said there is no evidence whatsoever of a term contract. And hence, the presumption, therefore, is that having been employed for quite some time, then this woman has already become a regular employee. And hence, she could not have been terminated simply on account of the end of that term contract as indicated, precisely because there was no term contract to begin with. There is no day certain with which they can say that the term had ended. Okay? So that ends my discussion. I will have to send you my handouts because we have to fix it pa. And I hope I have been able to clarify some nuances of labor law. And I really enjoyed spending my morning today with all of you. Thank you very much for your questions. They were, it led me to think of a lot of things, and that's what I like, no? Maraming salamat, and have a good day. Good luck! Kayang-kaya nyo yan. Bigyan natin ng magandang laban, lalo na sa labor code. Thank you very much. Bye-bye.
Thank you very much, Dean. For sure po maaalala namin yung lecture and your father's mnemonics during the bar. Ayan, so at this point, we would just like to show our gratitude by presenting an electronic certificate of appreciation, if I may remember. This certificate of appreciation is presented by the Philippine Association of Law Schools together with the PUP College of Law to Dean Ada Abad for imparting her knowledge on the subject of labor law during the 4th edition of Caso Discurso, a discussion on the latest Supreme Court decisions given this 27th day of September 2021. Signed, Attorney Jemmy Lito Festin, President of the Philippine Association of Law Schools and the Dean of the PUP College of Law. Thank you very much, Dean. Thank you for your time.
Thank you very much. Salamat. How do I get out of this? I just leave?
Yes, Dean.
Okay, thank you. Bye. Thank you very much.
Thank you, Dean.
Have a good lunch.
Thank you, Dean. Again, thank you very much, Dean Ada. To our viewers, we have another lecture tomorrow, September 28th. Please tune in again at 1 p.m. in the afternoon for the discussion of the recent jurisprudence on criminal law. It will be given by no other than Dean Festin himself. Again, this event is brought to you by the Philippine Association of Law Schools together with the PUP College of Law in collaboration with Central Bookstore. Thank you to our sponsors as well, Rex Bookstore and My Legal Wiz. Don't forget to give some stars if you think this lecture was helpful. This has been Meg Reyes, your host, and we hope to see you again tomorrow. Stay safe and stay healthy. Bye!